Well, hello, everybody, and welcome to Legal Lounge this week with APA. I am subbing in for Juliet. As you'll notice, I am not her. My name is Christopher Malcolm. I am a photographer, director, and cinematographer based in Los Angeles. I am not a lawyer, so thankfully we have a lawyer here on the line with us, Stephen Doniger. Stephen, you want to introduce yourself?
Everybody, Steve Doniger with the law firm of Doniger Burroughs. We are an arts and entertainment firm that focus on copyright infringement litigation. We work with a lot of artists, a lot of photographers, and here to share some knowledge.
Great. We're fortunate to have you. And today's discussion will focus around every photographer's favorite love-hate topic, which is social media. It's one of those things that everybody's always telling us to post. It's one of those things we almost can't get away from social media these days, but it's always also a little bit of a tricky area in terms of infringements and, where can we post, when should we be posting, where should we not be posting, the bigger questions. So let's just start off with an easy one. Why don't you give us a little bit of like a overview of the current landscape and let us know what's going on out there right now and some things we should be looking out for.
So there's a lot of stuff going on that'll make a lot more sense as we kind of get through the details of it. But among the larger cases right now that are being addressed in the courts, the battles that a lot of photographers are fighting to protect their rights, one of those deals with there have been two overlapping issues that deal with people posting on social media and then those posts being used by third parties without their permission, and then the effort to try to enforce their rights in it. One of those is something called the server test, which is the law in California in the Ninth Circuit, but not the law elsewhere. So it gets a little bit confusing. And essentially what the server test says is that unless you make a copy, if you're only embedding an image from social media and not actually copying the work directly, then under the server test, there can't be liability for copyright infringement. And the Ninth Circuit, has created that rule and says that makes sense. And other circuits say that doesn't make any sense at all. And that's something we should probably spend a little bit of time talking about, because as sad as it is, whether and to what extent you can enforce your rights when your work is copied off of social media may depend on where you are to some degree. The other argument, the other thing that's been a major issue and that's been being litigated quite a bit is what exactly do the terms of service, provide? And we'll talk about this, but the bottom line, and we'll circle back and explain all this in a moment, but when you post your work on social media, you give them a license, the social media companies, the platforms, you give them a license to use your work. You also give them a right to sublicense. And so when can a third party that got your image from the social media sites claim that they had a right to use it pursuant to a sublicense from the social media companies? When can't they? What do the terms of service say? And so there's been quite a bit of legal wrangling over that issue. And then, of course, the other favorite topic that everyone's talking about is AI, and we can get into that a bit. But those are some of the highlight issues that I deal with all the time.
Yeah, the AI. We'll get to that one in a section. That one's hard for me to talk about without my head exploding. So we'll talk about that one. We'll talk about that one last. But just to kind of piggyback on the server test. Let's start with the server test, since I think that since you were talking about that first. So if I'm understanding correctly, essentially that's saying that if you post something on, let's say, Instagram, for example, let's use an example. So if you post something on Instagram, another user takes that post and puts it in their stories or their, they don't download it necessarily, but they do like the repost in whatever. By definition, they can't be in breach of copyright, correct?
Right. So about 16, 17 years ago, the Ninth Circuit ruled on a case brought by Perfect 10 against Google and for showing these thumbnails and sometimes full-size images of their photographs. And what the Ninth Circuit said is that under the server test, if they haven't made a copy, right? If they haven't made a copy of it, but they're simply basically opening like a window to where it's displayed somewhere else, they're not the ones causing that display. The display is caused by the place yonder, and it's no more an unauthorized display or copying than if you put a window in your house so you could see what was across the street. Now that argument, I think, falls apart because it conflates the right to the. One thing a lot of people don't realize, and I just need to explain this first, is that the copyright, the rights protected by copyright are not really just one right. It's referred to sometimes as a bundle of rights, and it includes the right to distribute, the right to display, the right to copy, the right to create derivative works. There's a whole series of rights. The display right and the right to copy, to make copies and reproductions, are two different sticks in that bundle. And by saying you have to make a copy in order to be displaying sort of conflates the two. And there've been a number of judges. I'm in New York right now, particularly here. I mean, my office is in LA, but we also have a New York office that I'm working out of and speaking to you from right now. And, a number of judges out here have said, look, the server test doesn't make any sense because you can display something, you can cause an unauthorized display without making a copy. And to say you can't really conflates those two rights. So right now there's a case called Hunley versus Instagram, which just went up to the Ninth Circuit out in California, that created the server test and is asking the court to revisit the server test in light of the fact that virtually no one else follows it, and it doesn't really make sense. A lot of the big guns that support the server test and want things to be sort of freer to use on the internet have come out. There were a whole bunch of amicus briefs filed, and I filed an amicus brief on behalf of APA and a bunch of other artist organizations, arguing that the server test should be killed off. And we'll see how that plays out. But in the meantime, there is a split where if you are in the Ninth Circuit, you're basically bound by the server test, and if you're not, you're not. And what's crazy is in the Hunley versus Instagram case, the plaintiffs sought to hold Instagram secondarily liable for infringement on the platform. And what Instagram argued is, because we're in the Ninth Circuit and they had to be sued in California because that's where their corporate offices are, that's where they're located. Because we're in the Ninth Circuit, which applies the server test, the underlying users that are using the work without permission can't be liable for infringement because they're not making copies, they're just embedding. And if they can't be liable for direct infringement, then we can't be liable for secondary infringement, because for us to be liable for secondary infringement, there has to be a direct infringer, right? Because the theory that was being raised against Instagram is, hey, there's all this infringement by third parties on your platform, and because you provide these embedding tools and you don't really take any steps, you don't take reasonable steps to prevent this rampant copying on your platform, you should be contributorily or vicariously or secondarily liable for that. But of course, as I said just a moment ago, whether that's viable depends on whether the underlying infringers can be held liable for infringement. And under the server test, they can't be.
Right. So just to kind of and ask a question I'm afraid to know the answer to. So if let's say I take a photograph and it's got I'm just making this up. I take a photograph and it happens to have part of a car that was manufactured in Europe or someplace else, someplace that's not local, right? The European company sees it on my feed. They decide to build a whole social media campaign around that picture that's on my Instagram feed. And this is a big in theory, but in theory, could they then just roll that out wherever they want, essentially, as long as they don't download the image, and they just basically make a whole campaign out of it theoretically?
So that's the problem with the server test, is that to the extent that you would need to sue them in California or somewhere that uses the server test, which isn't many places outside of the Ninth Circuit. Yeah. But what it's done is it's led people to do what everyone generally thinks of as a bad thing, which is forum shopping. Like, if I have a choice to sue someone in California or New York or California or Texas or California or any number of other places where the judges have said the server test doesn't make sense, I'm going to sue them in those other locations because then I'm not bound by the server test. And that's one of the big arguments that that we made as a trade organization to the Ninth Circuit is, look, it can't depend on, it just can't depend on where you file suit, whether or not something is infringement. There needs to be clarity. The problem is that no other circuit has spoken to the server test. It's only been district court judges outside of the Ninth Circuit that have said this doesn't make any sense to us. So there's no like what's called a circuit split when two different circuits have different rules. It's just the Ninth Circuit and then all these other district courts that have refused to follow it. And until there's actually a circuit split, the Supreme Court's not going to take up the, is almost certainly not going to take up the question. So either the Ninth Circuit reverses itself to bring itself in line with what the rest of really most of the rest of the country is doing, or there just continues to be this uncertainty.
Interesting. So what, so just piggybacking off of that. So now what, right? So as an individual artist, when you post something, considering that, most of the, a large number of the people who are going to see it are going to be outside of your, outside the district, outside, the state, outside the country, outside, just in all around the world.
Right.
What protections do you have then to make sure that that thing that you're posting stays posted where you want it to post, as opposed to it just being utilized by anybody who sees it on the internet?
Yeah, so there's two different answers to that. Answer number one is that you do have a right to take action against unauthorized users as long as you can bring that claim in New York or in Texas or anywhere else that doesn't use the server test. The other answer, and we'll talk more about terms of service later on today, but you really want to look at what the terms of service of the platform are, because, and not just the terms of service, but the functionality of the platform, right? Like Instagram, when there was a court here in New York which in a case had decided that, well, Instagram's terms of service provide that it has the right to sublicense, and it makes embedding technology available if the post is public. Therefore, if the post is public, anyone has a right, like pursuant to the license that's given to Instagram, third parties have a right to use it. And when that ruling came down, people freaked out. And photographers started to a bunch of photographers ended up, turning their platforms private, because if it's public, then anyone can just link to it and use it for any purpose. And there's a big outcry. And as a result of that outcry, Instagram actually clarified that no, under our terms of service, we're not giving a blanket sublicense to anyone to use, the image. And around the same time, we had a case, my office had a case, McCucken versus Newsweek, where a court held the opposite, took a look at those terms of service and said, no, there's going to be a question for the jury as to what these mean, but I don't read this as saying that anyone has a right to do whatever they want. And then based on that ruling, the first judge reversed herself and said, yeah, no. So it kind of quelled this fear. But following that, Instagram ended up putting into place and announcing that it would be putting into place a number of other features to allow people to prevent that sort of embedding if they want to, and really have more control. So it's something that's constantly developing, but really that's, the short answer to your question is, other than being aware of where you can enforce your rights in the court system, you really want to be aware of what's available on the different platforms to control your work and the distribution and display of your work, because it really does vary.
Yeah, no, that's one thing that came up for me just big time. So I do stills and films. So I do films, and so I'm a Virgo. I'm very particular. I want my things, I want my work done a certain way and seen a certain way. And when I went to post a short commercial spot that I had done, I didn't realize this before, that there was, it asked me, it's people have the right to remix this. And I didn't at this time, I didn't know what this is a couple. I didn't know what remix was. And then I realized essentially what that means is that anybody who sees that can basically make their own video of it. So they can take what you've done, add different music, add a different soundtrack, do whatever, and repost it to their feed.
Which site is
Uh,
it?
this is on Instagram. This is on Instagram. So like the remix. So basically, like, so if somebody that I don't that just follows me sees this post, they can be like, oh, I like this visual. I want to redo this and make it something like that, and then repost it on my thing. Now I'm not sure if it says that it originally came from me or not, but to me, like, I don't care. Like, I don't want them changing it, either way. Like, I want that to be the thing, right? And so I was horrified by that. And so I immediately turned that off. But then it took me a little bit longer to realize that they can do that the same thing applies to my stills. So like you act like the stills as well, they can take and they can do whatever and they can repost because the stills can get remixed as well.
Right.
And you're right that there is an option to turn it off, but it's an opt-out thing. It's not an opt-in thing. So if you haven't turned it off, your current work can just be being remixed right now, which I found horrifying. I didn't realize that was a thing.
Yeah, and that opt-out option really came as a result of a lot of photographers and other artists just blowback, about the ability for them not to control their work once it's public. I mean, it sucks. It sucks. As a professional artist, you rely on a public Instagram page to promote yourself, to raise awareness, to show your work. If the cost of that is that you really lose control of that work, then it's a really tough decision. And I think Instagram realized that they had to do something. And if there's more pressure on them, it may well be that it becomes it's the default, not the opt-out. I don't know, but it's
the default would have been nice, but like you said, it's that caught between a rock and a hard place, I think, for a lot of photographers, because it's like in 2023 it's very hard to get yourself out there without social media. On some way, shape, or form, you need to be posting stuff somewhere, but there is always that question of like, what do I post? How much do I post? Do I post things that I could stand that aren't going to ruin me if they go crazy, and people start doing weird things with them, but also want to post my best work because it's, it's like a rolling portfolio. So yeah, that's always like that's a fun thing to have to deal with. I think as a photographer.
Good times. Yeah. And Instagram is far from alone on that. I think, TikTok is very well known that their terms of service, once you post something on TikTok, anyone has a right to use it in any way that they want, but only on the TikTok platform, right? Because TikTok wants other people to take other people's work and create new things and go viral, and then sharing and, doing derivative works and remixing things, and it all makes TikTok better. So you want to post to TikTok, you have to understand that not only does TikTok have a license to use your work, but there is an express sub-license for any other TikTok user to use your work for anything else, to the extent they're going to post that on TikTok.
Yeah, I've noticed that about I've noticed that about TikTok. Like it feels like the impetus of TikTok is to share and reshare and cut up and do stuff with the work. I mean, that's Instagram, kind of wants to be TikTok in a way, so like so it's trying to do some of the same stuff. But I think that's really much in the DNA of TikTok, is that idea that what you're posting there is a communal thing for people to kind of do reaction videos to, or to this to do, or to to whatever it might be. Now, what if somebody since I guess you still wouldn't technically have to download it. What if somebody, because I think there's a function like where you can repost, like I know you can like repost like Instagram to Facebook. I imagine there's probably some kind of functionality where you can repost like TikTok to Instagram. If someone sees your work or whatever on one platform and they remix it or whatever, and then they take a different platform, let's say like their Instagram, then take Facebook, or they take TikTok, and take the the link and share it across basically onto the other platform, which some platforms do. Is that technically a violation of the server test, because they're still not downloading it, but they're not necessarily staying within Instagram, like they're going from Instagram to Facebook to TikTok? Is that even a consideration?
Yeah, so I think we're conflating two different things. What I talked about earlier with the ability to take work and remix it, and like within a platform that you can make a copy. I'm not talking about embedding. I'm talking about actually like I can take this, make a copy, re-upload it, like change it around, make derivatives. That's different from the server. I mean, the server test is the server test. It's not platform specific. It's anything that's embedded. If under the server test would not be an infringement. And there's one more thing to say just about the server test that I think really just to point out how insane what's going on in Hunley versus Instagram is the district court dismissed the case and said, because they said, look, there can't be direct liability under the server test here in the Ninth Circuit. And if there can't be direct liability, there can't be secondary liability. Take it up with the Ninth Circuit. But think about this. A bunch of those users, the underlying unauthorized users who would be the direct infringers, if a bunch of those users are here in New York, you could go into a court in New York and actually get a judgment against them for infringement. You then could go sue, Instagram in California with a judgment in hand saying you are secondarily liable for this infringement that I got in a court in New York. And could a district court say under the law you can't possibly claim direct infringement when you have a judgment for direct infringement from somewhere else? Right. It's just crazy, but that's the state of the law right now, potentially.
Interesting. Yeah. So theoretically, it doesn't matter who all around the globe steals your stuff. If you can find somebody local that essentially stole it, sue them, and then, like you said, have that judgment, then take that judgment to the other locality, that will be, that's a lot of suing, I think, for most independent artist budgets. But it does, you're right, it does raise kind of a thorny, it makes it even more complicated than it already was.
I've got to say there are easy ways to pursue infringement claims. Congress just created the Copyright Claims Board, which is like the Copyright Small Claims Court that people can now go into without an attorney and relatively easily, bring their claims. And the one thing that we're not here to talk about today, but that I'm just constantly beating the drum on is just registration, like register. Because if you've got a timely registration, if you've registered your work before the infringement, you can seek attorney's fees and you can seek statutory damages, and things can become very, very worthwhile. I had a case that I took to trial where the jury, the evidence that went to the jury is the defendant's, to total actual value of the case, actual damages would have been less than $2,000. And the jury ended up awarding $30,000 in statutory damages. And then we ended up getting our attorney's fees, and it became a six-figure judgment. And that certainly doesn't happen all the time, but it's available, and it makes it worthwhile, or can make it worthwhile to pursue claims if the infringers are difficult. Because a lot of people, look, a lot of infringers count on that. A lot of infringers really count on, well, I can make this difficult. They're not, the photographer is not going to find an attorney willing to take this case on. And if you've got a timely registration, it's appreciably more likely that you're going to find someone willing to take it on a for a no fee arrangement. Make sure to find someone reputable, because there have been some attorneys out there handling a large volume of these cases that didn't do the best job, and it was some of their clients got some bad results.
Yeah.
But yeah, I don't want to take this off on too much of a tangent. I just thought that warranted saying.
Oh yeah, no, definitely. I always make I have a register, and making sure all my copyrights are straight for everything I do, pretty much as soon as I shoot, before they start going online anywhere, before anybody sees them, make sure that I have that protection. And then obviously, what besides obviously, everybody here giving you a flood of calls, what's the best way for a photographer to find like a reputable lawyer?
So it's a good question. There are a handful of attorneys that we know that handle copyright cases on a contingency basis. Some are better than others. Our firm is obviously the best. And I don't say that. No, look, there's some good attorneys out there. We We
Yeah.
we won a case at the U.S. Supreme Court last year, that clarified when registrations are, can be invalidated and the limits on that. We won last year, if you look at the, like Law 360 put out an article of the top copyright rulings of the year, and 2 of those 6 rulings were ours. One of them was a big fair use case in the Ninth Circuit. One of them was the case up at the Supreme Court dealing with copyright registrations. You want to look for firms that, and we kind of talked about this actually at the last legal lounge, was about how to pick an attorney. And you want to look for someone that's tried cases, that has actually been to trial, handled cases, that you want to make sure they know the law. You want to make sure that you just ask them if they've ever have there ever been any disciplinary actions against them. What are some of the results they've gotten? From the courts, not just go check out the last legal lounge for a fuller answer to that question.
Yeah, definitely. And I think Polly, who's helping us, I think she's going to put the link to the previous one in the chat. So anybody watching that wants to check that out, they can check that out directly there. Now, I have a little note here to ask you about this, and I don't know what it is, so I don't really know how to phrase this question. But I believe there's something called Section 512. Can you tell us a little bit about what that is and what we should know about that?
I can tell you all about Section 512. Section 512 is the notice and takedown section of a part of the Copyright Act that's known as the DMCA, or the Digital Millennium Copyright Act, which is a mouthful. The best way to describe it is sort of by analogy, right? Let's say that you have a public space and you allow people to come and demonstrate, or you own a shopping mall and you lease it out to stores who can come and set up their own shop and do their thing. If someone is like selling something or offering something in that public space that violates someone's copyright, or a store is committing copyright infringement, the mall's not liable. The park isn't liable. And what the law what Congress thought to some degree, and there's merit to it, is that just because you provide an online space that lets people come buy and sell and do their business and whatever, or an online platform that people third parties can use. If the online platform, the YouTubes of the world, were liable for all infringing content on their platform, they would quickly be sued out of existence. And so in order for the internet to function, you need to provide some level of protection for those online platforms from what third parties may do without their knowledge. On the other hand, you want to make sure that those platforms are responsible in addressing infringement on their platforms and don't have an incentive to let infringement run rampant because it creates more views and they make more money and whatever. So the deal that was struck is Section 512. Okay. And what 512 says is that, it says quite a bit, but what's relevant is that 512 says that if an online service provider, if there's infringing content on the platform of an online service provider, then they're not going to be liable for that, provided, one, they had no involvement in putting it up, they weren't the one that put it up, etc. Right? Two, upon receipt by a copyright owner of a proper takedown notice, they need to take that content down. And if they don't take that content down, then they can become liable for that content. And third, there's another thing that's become more and more relevant recently, which is they also have to have a repeat infringer policy. And if repeat infringers, if there's no penalty, right, and they don't enforce a repeat infringer policy, then they can lose their DMCA protection. And that's really important. Because I had a really well-known photographer client of mine contacted me the other day, and sent me a bunch of links and infringing content and what can we do about this guy? I think he's outside of the country, and a bunch of those were products that were being sold on Amazon and on Etsy and other sites like that with his photographs. And I asked him, I said, have you sent takedown notices? And he's like, that's a waste of time. I sent a takedown notice and then they just, they take it down and then they just pop up somewhere else. And it's this game of whack-a-mole and it's not even worth the effort. That used to be the case much more so than it is now. Okay, now, because the platforms have been told by the courts that if they're not enforcing their repeat infringer policy, they could lose their protections. Now they'll say, okay, if someone posts infringing content multiple times, they're banned from the site. And if it's a seller that relies on that site for a lot of their, generates a lot of income from that site, or really, it's important to them to not be banned from the site, which is the case with a lot of infringers. We've had a bunch of instances where those unauthorized users have reached out to our client or to us and said, hey, I'm so sorry about this. What can we do to make it right? And will you remove the complaint? Right? Because it's a strike and they want to get that strike off. Otherwise, there's a risk of them, losing their ability to operate on the site. And we've been able to turn a number of those into reasonable payments for our clients, like licenses and things. So even with infringers who are overseas, who would otherwise be outside of the jurisdiction of the courts, who we otherwise wouldn't be able to sue, because of the pressure of the platform not letting them continue to operate on the platform, we've been able to get some good results for our clients. So, and that's all pursuant to Section 512 of the Copyright Act, the notice and takedown provision, and the enforcement of repeat infringer policies.
No, that sounds great. I can't help but to think if it's some way how it could be applied to, the other, not strictly photography related, thing, but the idea working through, the limits of free speech on things like Twitter and hate speech and stuff like that that's going on right now. And when can you boot somebody off of a platform like Twitter, and what liability does Twitter have if somebody says something, or any platform have that somebody says something horrible on the platform that then becomes actionable in the real world.
Yeah.
So those things are almost similar in the sense that it means like a set of rules of exactly what happens when you infringe, or when you say something that's untrue, something like that. They almost feel a little bit related to me.
Right. They are. And that's sort of, that points to something else that I should mention about 512, which is that there's also a provision in there that the person sending the takedown notice has to certify that they have a good faith, but not only they're the owner and unauthorized use, but that they have a good faith belief that the use isn't fair use, isn't protected, by any laws, and like protected free speech. And if it turns out that they make that representation recklessly, or the knowing that it's likely to be free speech, and they're just trying to take something down because they don't like what's being said about it, right? Like, let's say that someone's criticizing your photograph online, or talking about like the worst photos of whatever. And you're like, I don't like that, I'm gonna do a takedown notice. If it reasonably could qualify as fair use, and you're weaponizing that takedown notice to take down stuff that you don't like, that you really otherwise would never write to, you can be subject to attorney's fees of the other side, if they then counter notice. I didn't mention what a counter notice is. The takedown notice, the other side has three options. They can either just do nothing, it stays down, they've got their strike. They can negotiate with you to try to remove the strike and try to reach an amicable resolution, or they can serve a counter notice. If they serve a counter notice, it's basically saying, no, I don't think this person has a right to tell me not to use it, either because I have a license or it's fair use or whatever it is. And if they serve a counter notice, then it puts the burden on the copyright holder, the photographer in most cases, but music or whatever also. It puts the burden on that person to file a lawsuit. So you serve a notice, the platform takes it down. If the other side serves a counter notice, the platform puts it back up. Because from the platform's perspective, they're not in a position to say who's right and who's wrong. And so if, once it goes back up, if you file a complaint then they'll take it down pending resolution of that complaint. But if you don't file a complaint in response to the counter notice, then it'll stay up. And that's
It'll
again,
stay
it's
up.
so that's how 512 works.
Interesting. And then, since we're on the topic of kind of infringements, because I mean, it can be, it can be hard to always know when your work is being infringed upon. I remember, last year I got a very pleasant email from someone telling me that I had won a photo competition in France. The problem was I never entered a photo competition in France. What had happened is somebody had come. I write for a site called F-Stoppers, and I used it wasn't even actually a really good picture. It was just I used a photograph, to as one of my on my article. Somebody had basically right click, just downloaded that, did some Instagram filter thing to it, submitted it to a competition, won the competition, and then I just got lucky. Apparently, the person who was running the competition knew my work and knew to email me. He was like, "Is this you?" And I was like, "No, that's definitely not me submitting that that things for
But
this
I'll take the
competition."
prize money.
Yeah, exactly. I'll take the prize money, but I did. That's definitely not me. So they but so I'm saying it was nice that they knew me, but obviously not everybody's gonna. That's not gonna happen every time. So it's hard to be able to know where your work is being used. What are some of the ways, especially on social media, but just in general, that photographers should be looking for their work and being able to find where their work is popping up that maybe it shouldn't be?
Yeah, so this is actually one of the easiest things that you can do. I mean, there's anyone can do a TinEye search. I mean, there's various websites that allow you to do reverse image searches. There's also a bunch of companies that have their own proprietary reverse search technologies that some of them you can open up free accounts for. Some of them will even act as sort of like a de facto licensing agent for unauthorized uses, and they'll find things that they'll scour the internet, they'll find uses, they'll then send correspondence on your behalf saying they'll find the uses, they'll then allow the photographers to go into the portal and say, yeah, this is authorized, this isn't, and then say, go ahead and you can send correspondence on my behalf for these. And then the licensing agent will say, hey, we represent this photographer and there's no unauthorized use, and please pay this licensing fee. And we work with a number of those companies that if they are unable to amicably resolve it themselves, and it's a reasonable enough claim, they'll refer it to us, and then our firm will prosecute. And there's a number of other firms that do the same thing and have relationships with companies like that also.
Yeah, that's great. Yeah, because that's always one, because especially with the internet stuff, just spreads like wildfire, and sometimes unless you stay on top of it, it's hard to always know where everything is at any given time. So now I'm going to ask. Go ahead. What are you saying?
Oh, I was just going to say. So it really is hard to know where everything's posted, and anyone who's got work, especially work that's a few years old or more than a few years old, you want to be searching regularly, because there's another area of law where there's a split of authority, and this time the Ninth Circuit in California is more favorable than the Second Circuit in New York. And that is in how far back you can go to seek monetary damages for an infringement. And in New York, in the Second Circuit, there's a Second Circuit case that says that because the statute of limitations is 3 years, we interpret a recent Supreme Court case, the Petrella versus MGM case, as saying that you can only go back 3 years in seeking damages. And so even if you didn't discover it until this year, if the post occurred more than 3 years ago, you can't seek damages. Or at least, can't seek damages going for more than 3 years back. The Ninth Circuit has just recently, even after that Second Circuit ruling, has said, no, we don't agree with that. If you didn't discover it if you reasonably couldn't have discovered it within the last 3 years, and you just discover it now, even if the post is from 5, 6, 7, 8, 9, 10 years ago, you can still seek damages going all the way back to the beginning because of the, because there's a 3-year statute, but you couldn't have known, and the statute doesn't start running until you knew or reasonably should have known. So it's another thing where there's a split of cases, but it's difficult for me when we need to sue a defendant in New York or somewhere that applies this 3-year really limitation on damages. It's always a tough conversation with the client to be like, yeah, I know you just discovered it, but you're limited to 3-year look back for damages. And so just, I want everyone listening to understand that, because it's really, that sort of really pushes the point of why it's so important to be diligent about at least just trying to find your work. Because if, courts are getting more and more savvy to that there are these search engines and ways of reverse image search technology. And the ones who are like, sometimes it's dangerous to know a little bit, but like it's more dangerous to know just a little bit than to know a lot. People who know that this exists think, oh, well, you could have found this. I mean, the truth is the internet is so vast and so huge that, even you'd have to run one of these search engines only on that photo for just weeks straight, just on one photo, in order to really get the whole internet. And so it's not a perfect technology, but it's important. It may be important in establishing the reasonableness of your delayed discovery to say, look, I've been trying to search forever. I haven't just been sitting on my hands and, not trying to find anything. Although,
Right. So
yeah. Although on the other hand, there's case law saying there's no duty to police the internet. So it's just like, it's kind of all over the place.
Right. Yeah. But yeah. So you essentially establish a paper trail, that you've been looking, and you just didn't find it. So in that case, it's easier to argue that it's reasonable that you didn't find it, because you can show that you've been trying, looking for these things.
Right.
Yeah. No, that's interesting. So I'm gonna jump into the kettle of fish now. And I know next week, I think next month is AI is the big topic. So I don't want to go too much into that. But I do want to touch on it in a little bit with regards to social media, specifically, because, obviously AI, in order to create an AI image, it's got to be trained on something. And, there's the Getty case now. There's all the cases now. Essentially, these algorithms are trained on existing data. So with regards to, as we were talking about, like, for example, the user agreement with Instagram earlier, where you're essentially letting them license, license the image or whatever. Yeah, sublicense the image. Is there anything in the user agreement stopping Instagram or Facebook or any of these things from basically just selling the entirety of every image that's ever been on there to the AI things to scrape to be fed into AI? Like, is there anything protecting that right now, or could they essentially do that because of the terms of the user agreement?
So shortest answer I've given you all day, nope, and yep. Nothing stopping them, and yep, they can do that. And
yeah,
I think it's only a matter of time. A lot of, like, we all know that the major tech companies that own the social media sites, whether it's Meta or Google, they're all developing their own AI, platforms and programs. And you have, if you've posted stuff on a Meta site, if you've posted things on YouTube, you have given them a license to use your work, and you've given them a right to sublicense that. There's no doubt in my mind that they'll use all of the artwork, all the work that's been posted on their platform to train, their software. And they, of course, depending on how much they're being offered by, third-party companies for that data set as for training, they would have a right to let those companies use it as well. So if you're really concerned with that, I don't know what to tell you.
Yeah, no, but yeah, I mentioned earlier, just as soon as I started talking about AI, my head explodes, because there's so many different, it's a very complicated issue. So I'll let you guys get into that next month. But that was the one thought I had specifically with regards to social media, because it's like, I know most photographers have been posting, especially on Instagram, for years, for years back. So, it's all there to be found. And like I said, even if you were, say, for example, just kill your Instagram account or, scrape it or whatever, I said, over the years, presumably people may have reposted your post or whatever, so it ends up in there, So it's kind of hard to really, you can't beat the internet. You can't defeat the internet. I guess that's the answer.
No, I mean, you and I talked about this briefly before this call, and things are changing quickly. And what someone did, 10 years ago, when it was inconceivable that artificial intelligence would be, taking data sets of images and creating artwork that, puts professional photographers out of business. I mean, it's not going to happen, right? Yeah, but right, but what was once inconceivable is now possible, and what you aren't thinking of now will be, the standard in the future. And just know that whatever you're putting on these sites, you're giving them an irrevocable license and or sub-license to use. And that's just what their terms are. And they've been building up something that's very, very valuable that they will exploit at some point.
Yeah, no, absolutely. Yeah, they'll be making that. And yeah, as I said, I can go down a rabbit hole when I start talking about AI, especially when I start thinking about, like if you were, because I mean, obviously, as like you said, like the thing about AI is it's not going anywhere. So you got to learn how to live with it somehow, or figure out some way to make it work for you. And so, like, if you're like a lot of photographers, for example, are starting to dabble in it now, and posting the results to their site. But then it adds, that raises the question, because again, like the copyright gets funky in terms of like how that AI image got generated. And I know they're kind of being legal cases working through the system in terms of where, what were the source images that went into making that image, and who owns those and how does that work? And so is anything photographers, just briefly, I mean, is there anything photographers should know about if they're posting AI work that they created to their feed, in terms of, are they opening themselves up to other legality from other areas, in terms of who might be, or derivative of that, that created that AI, if that makes any sense.
So can you ask that question again? I'm not sure that I understand it.
I know that, I got lost in my train of thought. No, so okay, so like if you're a photographer and you're dabbling in AI, right? Just because trying to learn it.
Yep.
And you create something in AI and you post it on a social media platform. Basically what are you opening yourself up to legally by posting AI, since the the questions around copyright and how those images get to be made isn't quite settled?
Yeah, and that really is the answer, is that none of this is settled. What is settled is that only work that's created by a human is entitled to copyright protection. So if you just give like some search terms to AI and it generates some work for you, and it's a purely AI created work, you can't claim copyright protection in that. The question is, can you be liable for creating it? And I don't think, unless you put someone else's image into that data set, my sense is that you cannot, because you didn't do any, you're not the cause of the copy being made in the data set. You're not the cause, you didn't make any decisions or choices in what was generated. You just said, like, hey, I want to see a llama surfing on a couch or whatever. I don't see any basis for someone to be liable for that situation.
Yeah, it's tricky. It's like, yeah, that's why my question got all wonky, because
I mean, look, we'll talk about this next month, but the issues are going to be, if something gets ingested into a data set that's being used for AI, right? Is there a license or sub-license that allow that to happen? If there's not, is it fair use? There's times that, like, I'm looking at something for, like, I mean, there will be fair use arguments that are made, and then beyond that, you're really going to get into what's the output from it, and is the output, if the output ends up being substantially similar to the input, could that be sufficient to establish, liability in the output, and against who, if it's really AI? I mean, if it really was just scraped by a bot and created by, the artificial intelligence, who's even going to be liable? And there's a lot of hard, like, really tough questions to wrestle with.
Right. Yeah. So I won't use up all of your next month stuff, but I figured I'd throw it out there. So I'm almost pushed you all the way to an hour now, so I don't want to use up too much of your time. But just as a summary, based on kind of social media, what we've talked about today, I mean, are there big things that we really should be talking about that I haven't pinged you about so far today?
Yeah, I mean, the big thing, no, not that you haven't, asked me about. I really think we've covered the big picture items, which is just be aware of the terms of service, be aware of the license you're giving, be aware that things change, terms of service change, functionality on the sites change, and what the site thinks is or is not okay for them or third parties to use your work on may change as well. So it's ever shifting ground. You're on, good luck.
It's a wild, wild west. We'll figure it out as it goes along. Well, thank you for that. And I said, I'm trying to think. I don't know if your information is there in the chat, or for people that may want to, may need to use your services or whatnot. Where should people be able to find you? Do you have a website? How do people reach out to you?
Yeah, of course. You can take a look at, you can just, if you look me up, Stephen Doniger, you'll find me, donigerlawfirm.com. Again, we have offices in LA and New York. We also have attorneys we work with in a number of other states. And always happy to help, even if it's just to give some advice.
Perfect. That's much appreciated. Much appreciated. And I also appreciate you taking the time to chat with us today. And thanks everybody out there for watching and chiming in. I see a couple questions in the Q&A that said how are the stills remixed, and how do we opt out of the remixing thing? I can't tell you off the top of my head, but it's in the settings thing in Instagram. It took me a little while to follow to figure out. I'm not the sharpest when it comes to social media, so it took me a little while to follow it, but it's in there. And then the other question is about Q&A. It's about AI. So we'll you'll address all that in next month's lecture. So
yeah,
thank you. Thanks for your time.
Hey, thanks so much.
Thanks everybody. Hey, bye.